Good morning, everyone. Thank you for inviting me here. This feels really funny to me, but I'm going to work with it. I am an elder law attorney, and I practice elder law in addition to consumer law. I'd like to tell you a little bit about Legal Services of Northern Virginia. You may hear it referred to as legal aid, and we provide legal assistance to low-income members of our community for free. So if you have a legal issue, I have a card I'm going to pass around. You can contact Legal Services, and we may be able to help you, and there will be no cost to you. We have excellent attorneys. I have a big voice. Sorry. We have a great team of attorneys. Two areas of law that Legal Services does not practice and cannot help you with is immigration and criminal law. So if you have those issues, unfortunately, our funding prohibits us from doing any type of legal work in those areas. But I want to talk to you about something that's important, not only for people over 50, but I think for all adults. And that is, how are you going to plan for a situation where you're unable to speak for yourself? Or how is your mother going to plan for a time when she's no longer able to sign her name on legal documents or even on a check to pay the utilities or pay the rent? How are you going to help a disabled person after they reach adulthood? So if you have a disabled child, you have the legal right to make all their decisions. But as that child becomes an adult, you need a new tool that's going to enable you to assist in making decisions. That tool is called a general durable power of attorney. And I think every adult should give their power of attorney to someone else, because you just never know if you're going to get hit by a bus on the way here. I mean, I hate to talk about horrible events occurring, but as an attorney, I plan for the worst and hope for the best. So suppose you do get hit by a bus on your way here, or you go home and you have some catastrophic illness and you're unable to speak. You have a stroke that renders you speechless. At that point, it may be too late to take the easy road. There are other legal roads that can help you take care of an incapacitated person, but I'm talking about making a plan today that will help your loved ones take care of you, or help you take care of your loved ones if they're no longer able to speak for themselves. And that tool is a general durable power of attorney. So it's general. That means that it covers A to Z. You're gonna give, so for purposes of this talk, I'm just gonna use a mother and daughter. And the mother is gonna give the power of attorney to the daughter, just to illustrate what I'm talking about. So if the mother gives the power of attorney to the daughter is going to be able to write checks, pay the rent, apply for health care, stop health care, make medical decisions, talk to the pharmacist, talk to the doctors, talk to the landlord, talk to the bankers, pay the electric bill, go grocery shop and write a check with confidence that you're not going to be questioned in your authority to sign someone else's name, because you'll have a general durable power of attorney. So it also will allow the daughter to sell a house. It will allow the daughter to buy a house. It will allow the daughter to make investment decisions, maybe cash out money out of the bank or another investment like an IRA. So it's going to be very general. That being said, the mother can always say, I don't want this power in my documents and I don't want this power. So the mother can say, I don't want my daughter to have the power to sell my house, or I don't want my daughter to make any changes to my life insurance. So we start out with a really broad document, but then I can narrow it down for you if you're not comfortable with giving a power of attorney that's that broad. It's durable. So it's a general, durable power of attorney. Durable means it survives the mother's incapacity. So say the mom gives the power of attorney to the daughter today, and then the mom goes home and runs to the grocery store and gets hit by a bus, and she's in a coma. She's then what we call legally incapacitated. So she can't speak for herself. She can't make medical decisions. She can't consent to any operations. She can't approve any medical treatment associated with her comatose condition. But because she executed that general durable power of attorney, the daughter can step into the mom's shoes, even if the mom is incapacitated, and make decisions for her and tell the doctor, yes, do this operation. No, don't do the operation. Stop care. Continue care. Keep my mom on life support. Take my mom off life support. Without that document that the daughter and the mom executed the day before she became incapacitated, the daughter isn't going to be able to speak for the mom. But because they executed the general durable power of attorney, the daughter will be able to step into the mom's shoes in the event of a catastrophic illness. And don't just think it's used for catastrophic illness. I have clients that come to me and say, my mom has the housing voucher. I'm listed on as a person that lives in the apartment with her, and I do all the paperwork. But housing, Fairfax County Housing, won't let me renew my mom's voucher, and we're going to be kicked out of our apartment. If you had a power of attorney, the daughter would be able to show that document to housing and renew the lease. So the uses for a general durable power of attorney are endless. And I think it's the first tool that everyone should get or sign or execute in thinking about the end of your life or the end of a loved one's life. And it's important to do it today because you don't know if someone's going to have capacity tomorrow. So when I started out, I said Legal Services of Northern Virginia provides legal assistance for free, but it's income-based. So it is income-based. However, as the elder law attorney, I will see anyone over the age of 60 regardless of income. So every single one of you can make an appointment with me, and we have offices all over the county and in Loudoun County, Prince William County. We have an office here in Arlington, and we have an office in Alexandria. So any one of you can call the number on this form that I'm going to pass around, and you will get a 1-hour appointment with an elder law attorney. And 1 hour is plenty of time for the attorney to draft and execute a general durable power of attorney for you or for your mother or for your father or for an adult child. So if you're not over 60, say you're 40, but you're taking care of your mother who is over 60, then the mom should make the appointment, because that way I don't have to look into the daughter's income, who is only 40 and might not be qualified for our services. So every single one of you should be calling legal services to get a power of attorney. Another reason I like a general durable power of attorney, and I'm saying the whole name of it so that hopefully part of it will stick with you. Because if you're anything like my family, they'll ask me a bunch of legal questions and I'll tell them and they'll be going, yeah. Oh, okay, great. And then the next day they call me and they say, what was that thing about that power of attorney thing? Or what were you saying when you talked about a will? So it's complicated language. So I'm repeating it, and just bear with me. Hopefully, if I throw it out at you all enough, it's going to stick. One of the great things, aside from everything I've already said about a general durable power of attorney, is that it's private. Okay? Nobody has to see the contents of that power of attorney. So suppose we have the mother-daughter situation, and then brother comes out of nowhere and says, I don't think you're doing a good job, sister. I want to see that power of attorney. You're under no obligation to show it. That power of attorney, the mom can show it to the son if she wants, but it's completely private. It doesn't have to be on file with the court. And when you use it, sometimes doctors will ask for proof that you have a power of attorney. I tell clients, show them the signature page, which is usually page 7. And maybe the exact paragraph showing that you have the authority to make medical decisions. Don't make copies of it and leave it with everyone. Because then if the mom does decide she wants to take all that authority back and maybe give it to the son, she has to go to everyone who has relied on it and say, never mind, I ripped that paper up. You should also know that if you execute a general durable power of attorney, you do not give up any of your rights. So you can execute a general durable power of attorney today, and in 20 years, it's going to be as valid in 20 years as it is today. So just because you've executed that document doesn't mean it has to be used, but it's there just in case, which is great planning. It's planning for the worst, but hoping for the best. So it doesn't have to be used right away. And you should have some peace of mind just knowing that if something happens to you, someone that you trust can step into your shoes and help. But again, you don't lose any rights. You don't give up the right to speak on your own behalf. You don't give up the right to do your own banking. You have something in place in case you can't do your own banking or sign your own checks. So I think there are so many reasons to do it. If you wait too long to do a general durable power of attorney, suppose mother and daughter There's no document executed. Mom leaves. She goes home. She has a catastrophic stroke, and she's in a coma. But she's very healthy. The daughter would then be in the difficult and costly, extremely costly position of having to go to the court and petition to be appointed the guardian, which means the caretaker of the mom, be appointed the guardian of the mom. That's a public proceeding. You may or may not qualify for my help, my free help. It takes a long time. I have a client who I met with in January, and she's seeking guardianship over her disabled daughter. So she initially saw me in January, and she has a court date next week. So 11 months from start to, and we're not even done. And then once the court appoints a guardian, suppose the court appoints the daughter to be the guardian of the mother, it's public, it's costly, and you have to file a report once every 3 months with the court, with bank statements, with an explanation of how you have spent every penny of that incapacitated person's money. If you have that general durable power of attorney, you may remember I said in the beginning, it survives incapacity. So, same situation, mom and daughter, they have the power of attorney. Mom has a stroke. She's in a coma. The daughter can just step into the shoes of the mom and doesn't have to report to anyone how she's spending that money. Of course, you can't misspend the money. You can't spend it on yourself, which is why you should take care in deciding who's going to be your agent. And by agent, that's the daughter. The mom is called the principal. So you should give that some thought before you all come and see me to get a power of attorney. I also like to recommend that people, if they can, that they appoint co-agents. So if you are lucky enough to have 2 children that you trust, if you're a mom and you have 2 children you trust, I like to draft a general durable power of attorney that says, my agents shall be daughter 1 and daughter 2 who are authorized by me to act together or alone. So that way, you're giving your children the ability to go out of town with some peace of mind. Because if something happens to you while one child is gone, the other child can step in and make decisions alone. It's also nice for the agent, for the 2 daughters, to be able to talk about it and work together, generally. Depending on your kids, they may be prone to fighting. I know I have children that fight, but I'm sure you all don't. But I do think it's a good idea to have 2 agents. And in the alternative, have a backup agent. So if something happens to the daughter, so mom is in a coma, daughter has the power of attorney, daughter leaves the hospital and gets hit by a bus and is dead. Mom is back in the same spot, the same legal position she was in before the general durable power of attorney was executed. If you say, I give my power of attorney to my daughter, and if she is unwilling or unable to assist, I want my agent to be my son. That way, if something happens to your daughter, the son can step right in. You can do a power of attorney 2 ways. You can have it effective immediately, which I always recommend, just for ease, and it prevents you from having to see someone else in order to use the document. But if you're not sure about a power of attorney and you may not feel comfortable executing a power of attorney for whatever reason, and if you tell me you're not comfortable executing one that's effective immediately, I'm going to ask a few questions, but generally I will respect your decision. You can execute a springing power of attorney, and it's called springing because it springs into effect upon the happening of an event. So mom and daughter have the general durable power of attorney, and it's a springing power. Mom gets hit by a bus and is in a coma. At that point, the power of attorney will spring into effect. However, a springing power of attorney isn't just as easy as it sounds. You have to have two doctors' written opinion that mom is no longer able to act for herself. So it can be a little bit cumbersome. So I do recommend that if you have someone you trust, that you do an effective immediately general durable power of attorney. Do y'all have any questions? Yes, ma'am. I'm sorry? The children have to be adults. So they have to be 21 to take the power of attorney. If you have a 17-year-old daughter, that's not going to work. The agent, the person that's going to sign, if you can't sign, has to be 21. Any other questions? Yes, ma'am. So for a general durable power of attorney that's immediately effective doesn't mean you need to use it. Like if I do one today and give my power of attorney to my daughter, it's a safety net for me. I am able to write my own checks. I'm able to make buying decisions. I have executed it for that day, and it may never come for that day that I can't speak for myself. So I see clients who have a general durable power of attorney in place for years before it's ever used. I have my mother's power of attorney, and it's very convenient because my mother lives in D.C. and I live in Virginia. So, sometimes if it's snowing, she's just not comfortable going out. She's afraid she's going to slip and fall or something. So I can go grocery shop for her and pay with her check because she's given me some checks. So I may use it once every winter to grocery shop for her. Or she was in the hospital once, so I paid the mortgage for her. And I was in the hospital, I wrote the check out for her. She watched me, I signed it, we mailed it, it was accepted, and there was no interruption in her living conditions because I have that power of attorney. I don't use it often. So I sign my name, so I write Denise Pitts, comma, power of attorney with hyphens between each word, so power dash by dash attorney. And then I sign my mom's name underneath it, power of attorney for Mrs. Patton. The bank will sometimes ask for a copy of it. And I don't like to give the bank a copy. When my mom's bank asked, I took the power of attorney into the bank. So if that's feasible, that's what I recommend you do. And let the bank look at it. And but ask them not to make copies unless they have to. And then generally they'll make a copy of the first and last page. So you don't want that document copied and out there for everyone, because then you lose the privacy aspect. And if my mom ever decides she doesn't want me to have her power of attorney, she will have to go around and tell the pharmacist, don't talk to my daughter about my medicine, to her doctor, don't talk to my daughter about my medical condition, to her mortgage company, don't talk to my daughter about my bills. So don't send copies. More questions? Yeah. So if you give the power of attorney to someone and they abuse that power or they misuse it and maybe they spend all the money to buy themselves clothes, you have a remedy. It's not easy. It's to go to court and sue them for a violation of their fiduciary duty. So that's why it's important to pick someone that you trust. Yes, Stacy? So the question is, if someone is married, do these rights pass by operation of law because you're married? No. No. A lot of things happen by operation of law between husband and wife when the first spouse passes away. But we're not there yet. We're not talking about wills. We're not talking about death. We're talking about you not being able to speak for yourself. So you might think, oh, well, my husband can sign for me. And your husband probably does sign for you. Like I sign my husband's name sometimes. It's not the best practice. And if the doctor or your insurance company say you can't sign for that person, then you need that power of attorney. And there's no sense in putting it off because none of us know what's going to happen tomorrow. And none of us can say like, oh, I'm going to have full capacity tomorrow. Hope we do. But it's really important. And it will make life so much easier for the person taking care of you or for the person you are taking care of. So you may think, oh, this doesn't apply to me. But if you have a mother, if you're someone, even a sister who is your age, you all should be talking about who you should be thinking, who can take my power of attorney, no matter what age you are. And as a general rule, when I see a husband and wife, they give the power to each other as the first person. So remember I said I like for clients to have a backup power of attorney. If you're married, you may just want to give the first person will be your husband to act on your behalf or your wife. But you should also have someone else, because your husband could die or your wife could die. So it's just good planning to be as comprehensive as you can be when you come in and start talking about a difficult subject. So make sure you only have to talk about it once. More questions? Yes, ma'am. It doesn't have to be family. It can be whoever you want. It has to be someone that you trust to have control over your checkbook, over your ATM card. I have my mom's ATM card. And for instance, I have it, and we're planning a vacation in November. And so I made the reservations, and she said, well, I'll pay for half of it. So I'm able to go to the bank and just take her half of that money without having to have a court approve that expenditure. Other questions? It's free. Free. I can do it for you for free. That's my favorite thing to tell people. Like this powerful tool that every single person should have. You can come in to my office. I'm in Fairfax, but you can go to the Arlington office. And when you call this number, they're going to put you at the right office. And you can come in. We can meet each other. I can do the power of attorney for you, the general, durable power of attorney for you, execute it, copy it for you, and you will leave within 1 hour and it'll be done. So the unpleasant topic will be closed. So it is income-based. If you're over 60, I can see you. If you're over 60 and you come and you see me and you have $1 million in the bank and you're making $5,000 a month, I can still do the general, durable power of attorney for you. But I will refer you out to a private attorney to do more sophisticated estate planning. So if you're over 60, or the person who is going to give the power of attorney is over 60, you're good. Come see me, it's free. For those less than 60, still call because you may qualify for our services based on your income or lack of income. So if you're over income, unfortunately, you won't even get an appointment. We will say, you're so far over income and we have such limited resources that right away we're going to say, call the lawyer referral service. We're going to refer you to another way to get the document done. I know from talking to people like you and other colleagues that are in private practice that a general, durable power of attorney is approximately $2,000. But I can do it for you for free. And the document that I give you is just as effective as the $2,000 one, but mine is free. So I really want you all to call and look into this. And we have interpreters. We have in-person interpreters and on the telephone interpreters. So language is not a barrier. In dire situations, we can come to you. So if your mom goes grocery shopping and gets hit by a bus and she's in the hospital, and it looks like she's got like three broken legs. Sorry. 2 broken legs. And it doesn't look like she's going to get out of the hospital soon, but her rent still has to be paid. I can come to the hospital. So I want this for you more than you want this for you. I'll do anything I can to help you get this document in place, and so will my colleagues at the other office. So I'm going to pass these around if y'all just want to take one. It's how to make an appointment with me, and I'm hoping I see everyone come to my office. More questions? We don't do any immigration. We are not allowed, our funding prohibits us from doing immigration. Our funding prohibits us from doing criminal law. So if you are arrested because you were shoplifting, or you were drinking and driving, or you got a speeding ticket, don't call me. I won't be able to help. But almost anything else, we can help. I've limited my talk today to the general, durable power of attorney, but I can do a will. I can do a healthcare directive where you give wishes about how you want to be buried. Do you want to be on life support? Do you want to be taken off life support? We can do a document like that. We do disability law, Social Security law, Medicaid law. I'm also the Medicaid attorney. So if you're having trouble with Medicaid, give me a call. It's free. The power of attorney is only good as long as the mother is alive. So when the mother dies, then hopefully she has a will. Some people, sometimes you don't need a will, and if you come to me and say, I really want to do a will, we're going to talk about whether or not you need one. There's some estate planning tools that we can implement to keep you from having to do a will. And I like for all of my clients to have the most privacy available. And a will is not very private. So even if we end up having to do a will, I like to try and take assets out of the estate and have it trickle down to your kids or other beneficiaries in other ways. But I can talk about that when each and every one of you come to see me about a general, durable power of attorney. More questions? Yes, ma'am. No. So only the person giving the power of attorney has to be there, the mom. I generally recommend that if you're giving your power of attorney to, say, your daughter, it shouldn't be a surprise. Your daughter should know that's happening. But like for scheduling purposes, I only need to see the person giving the power away. I mean, you can go on, and I've had one client that wanted to do like 5 alternate agents, and I said 3 is probably enough. You can do co-agents that talk together, and then if you have family or another trusted person, you can do 2 co-agents and then a backup agent. So that if one of the primary agents, the first 2, are unwilling or unable, say daughter number 2 moves to California, then the backup agent can step in privately. So you don't have to go to court and ask for permission. When you are in a court situation where you're appointed by the court and that you file an accounting with the court every couple of months, the judge has the authority to question every penny you've spent. So it's not private. It's intrusive. It feels uncomfortable to have someone saying, like, did you really need to spend $100 on groceries? Couldn't you have gotten by with $50? I mean, you're an adult. No one wants to be treated that way. And a general, durable power of attorney will keep that from happening and give you privacy. A general, durable power of attorney is when you're alive. A will takes effect when you die. So if the husband or wife die, a power of attorney isn't going to help, because a power of attorney only helps during your life. When you die, the power of attorney is gone. And if you don't have a power of attorney, when one dies, it doesn't matter, because then you're in a different section of the law. Then you're in wills, not power of attorney. So as a general rule, if you're married and you die, and it's a first marriage for both spouses, everything goes to the surviving spouse, whether or not there's a will. It's the surviving spouse, or what we call the second to die, that really needs the will. Right, because the surviving spouse could die, and then a child could then be appointed to wrap up affairs, but you're going to have the court looking over that child's shoulder, and it could lead to fighting among your kids that could lead to costly legal fees to settle a dispute. So if you have $500,000 that you want divided by 3 for your 3 kids, but you don't have a will, someone gets appointed, it would be so easy to spend $500,000 on legal fees determining who should get what. At the end of the day, no one's going to get anything. So it's important to have a will. It's really important for the second surviving spouse to have a will. So if you know someone whose husband or wife has recently passed away, it's urgent for that person to get a will for the surviving spouse. Yes. No, but upon the death of the second person, then it's going to go to the kids. And it may not go to the kids how the parents want it to go. So, in situations, so that's a situation that's almost a perfect recipe for disaster because no one's going to be happy. So if you know of someone or you're in a second marriage and there's income inequality, or if you're in a second marriage at all, you should take steps to execute a will to provide for your children how you want and not by operation of law. Yes, Virginia is one of the few states or commonwealths that still recognize handwritten wills. So suppose some of you don't have a will. You can go home tonight and write out your will. I want everything to go to my husband, or I want everything to go to my kids, and I want my jewelry to go to my son, or I want this piece of jewelry to go to my daughter. Handwrite it. The entire document has to be handwritten, and it has to be signed by you. It can be cumbersome to administer a handwritten will, but it can be done. No, it does not have to be notarized. Right. That's my legal opinion. Yeah. So, I have stressed the general durable power of attorney as a very, very important document, but don't misunderstand that I'm saying other estate planning documents aren't important too. I think the first thing everyone needs to do is the general durable power of attorney. Then you can have some breathing time to think about how you want your will to read, who you want to get what. But the first thing is that general durable power of attorney. Yes, ma'am? Right. So a power of attorney can cut against, because the son has already given that power of attorney to his dad. And so, the wife could say, and legally, that's the correct outcome. Does it feel right? No. But unless the son revokes that power of attorney, that's the way it is.
A consult.
And privately, for free.
For free. Yeah.
So I hope you all come have a meeting with me or one of the elder law attorneys. And Stacy is right. We all need this document. It's going to make life so much easier for those that are caring for you. And you might think, I'm caring for myself, but we don't know what tomorrow will bring. So I hope tomorrow brings you all into my office. Thank you.